Hey, good day, everybody. Welcome to the Deal Scout. On today's show, we're going to talk about legal aspects from the perspective of a startup. And with it, I brought one of my attorney friends to come on and talk to us about the legal world of startups and what should a startup consider when building a brand or building a business. So, with that, Jeff, welcome to the show.
Hey, thanks so much, Josh. It's great to be here. Really glad to join you on this.
Yeah.
I am an attorney. Don't let that turn anyone away from watching any further in the video here. So, we're going to talk about some practical stuff, and I think maybe just to give a little bit of perspective as to how I approach stuff. I just love the chaos of startups. So there's a lot of chaos in startups. There are a lot of things that can go right really fast, and a lot of things that can go wrong really fast. And that's one of the reasons that my law firm practice focuses on startups. It's just an exciting place to be, as every founder knows.
Yeah.
So
So with the chaos of startups, I've myself have been in startups for a lot of my professional career, and there is a lot of chaos. So from a legal perspective, what kind of things can can occur for startups, based on some of your experiences?
yeah, oh man, that's a really open-ended question. Basically, anything that can go wrong probably will at some point go wrong, right?
Mhm.
That's why a lot of startups end up doing a lot of cleanup afterwards once they finally decide to bring on a team. So at my law firm, Intellectual Strategies, what we do is we actually bring together a team that would be like a fully scaled legal team that a normal full-scale business would use, but we make it available on a fractional basis, meaning people can hire us as a team for slices of time. We call it a fractional legal team model. So the reason we do that, getting to your question, is that so many different things can go wrong. It's hard to find one attorney who can either prevent or fix all of the things that can go wrong in a startup. So on our team, what we do is we have attorneys with different expertise. You might be in the stage of forming your business. You need your LLC or you need your operating agreement set up. That's an area where we can step in, we can help you avoid problems, hopefully, or we can fix them if they need to be fixed after the fact. It might be funding. It might be getting patents on your new idea. It might be setting up relationships with vendors. Where are you going to buy your products, or what consultants are you going to hire on? It might be employee stuff if you're at the stage of employees. There's just so many areas. One area you mentioned at the beginning is branding. Branding is an area where a lot of questions can come up too. So
Yeah. Well, let's dig into the pure startup. I've got an idea. I go out, I'm a domain guy, right? So when I have an idea, which I've got a lot of them, I'll go out and I'll buy 15 domains and I'll start looking at that. So when it comes to branding for a startup, like if you're like me, I'll go out and I'll spend a ton of money and then I realize that it might have a copyright or a trademark. So maybe let's start with this is what is the difference between a copyright and a trademark and how does that apply to a startup?
yeah, that's a great foundational question. So there are really four types of IP, intellectual property, right? Trademarks and copyrights are two of those. Then you also have what's called trade dress, which is similar, and then you have patents. But let's focus on your question about trademarks and copyrights first. So trademarks protect anything that you use as a brand identifier. So that means a lot of times your name is a brand identifier, right? You want people to be out there and recognize your name as the source of goods or services, or the source of the products or the services that they want to buy. So anything, a name, a logo, might be a color, might be a sound, might be, a combination of those things, a tagline. Any of those things can be a source identifier or a trademark. On the other hand, a copyright is doesn't really have anything to do with branding. Now, there's some overlap, and I'll explain that in a second. But a copyright is all about a new artistic work or something that you've created. So you can create paintings, you can create music, you can create the notes for the music, or you can create the lyrics for the music, or you can create a book, whatever it might be, right? You've got this new artistic work that you've authored, you've created it. And so you can see that copyrights are the artistic work, and trademarks are the protection when you use that artistic work for your brand. So you can actually have material or a concept, a drawing, a graphic, or something that qualifies both for copyright protection and for trademark protection at the same time if you're using it as a brand identifier.
Got it. So when it comes to my brand, let's just even use the Deal Scout. The Deal Scout is a trademark brand, right? We got someone to help us set it up because I had no clue, what I even needed. But
Yeah.
now, I was just doing a search online and I saw another YouTube channel that actually says Deal Scout, right? It's very, very similar. So when it comes to trademarks, like why do we set them up? What does it protect? What the heck do I do if I'm a trademark holder or if I created something first? Or what if I didn't have a trademark and then he created it after me? Like what does that look like?
Yeah, so it's a complex world. It seems like it should be really simple. Let me start off by saying that I love trademarks because I think trademarks can be one of the most valuable pieces of your business. Out of everything you do, you're creating a product or you're creating a service business where you provide certain services like my law firm. You're creating a business. And in the end, if your goal is to eventually have that business be worth something, maybe sell it off or bring on investors, the branding that's protected by your trademark actually in many cases is the most valuable part of your business. Not that the people aren't valuable or the products, it's just the brand itself is why somebody else comes in and it's why they found you in the first place, right? It's like, oh, the Deal Scout, I like something I want to be a part of or I want to own it. And they come and they're buying it because you have the brand, you've protected it, and there's some revenue model associated with it. There's some audience associated with it. So it's trademarks. I can't overemphasize for small businesses the importance of trademarks. That being said, they're relatively easy to get started. So it's one of the first things that a small business owner can actually put into their quiver, right? They can go out and they can get their trademark application filed. It goes through. It's slow for you guys, slow for business owners, but rather quick on the attorney side of things. So people can go out and they can actually get their trademark pretty quickly and pretty easily. That being said, there's a step in between kind of having the idea for your brand and going out and really developing and spending money on your brand that I think everybody should do. And that's what we call a preliminary trademark registration search. So it's really just going out and saying, if I do this, if I launch the brand, if I put $50,000 behind this, if I build out the websites, like am I going to run into any obstacles? And there's kind of two obstacles you can run into. But that all we kind of investigate that at the search stage. So the search stage really means you're going to go out and you're going to see if you're going to evaluate, is there a likelihood that we can actually get and protect this brand for the types of products or services that we want? So a lot of people will do that search. It's also called a clearance search sometimes, and they'll go out and they'll do a clearance search to see if they're going to run into legal obstacles. I don't want to get too far in the weeds here because I don't know the answer that it goes to your question, but it's kind of an important concept. When you do a search, there's really two things you can search for, and this is true with a lot of intellectual property. One, you can search to see if you're eligible to get protection for yourself, right? The Deal Scout. Can you protect it yourself? You've already done that. You've gone through the process. The U.S. Patent and Trademark Office has examined your application and they've granted it to you, I guess, and you've got the registration and they've said, okay, yeah, you're eligible to have this protection. And that means you can stop other people from using it if they're using it inappropriately. The other half of the search is related to, it's kind of like the opposite side of the coin. Same coin, different side, and that's the infringement aspect. So, somebody could be using, you can go out and you can say to yourself, can I get my own protection on the Deal Scout? Then you can also ask the question, if I start using the Deal Scout in the ways that I want to use it, is somebody else going to think that I'm trading on their brand? Or is somebody else going to say that I'm infringing their brand? Like I say, they're two sides of the same coin, but they're not the same question. And so they really are two different questions that you can look into both of those up front before you get going. So that's kind of the first step, I would say. You get your idea, you go out, you maybe register your domains. That's not a super expensive process. But one of the first things before somebody, goes and puts puts their branding into their molds that they're making their product with, or before you go out and you create a bunch of hard copy materials, or spend $20,000 on a fancy website, whatever it is that you're going to put a big investment towards. Uh, Clearance search for your brand is a pretty fundamental, easy thing to get done, and give yourself some assurance that there's a lot less risk someone's going to come and tell you you can't register that brand for yourself, or you can't use it because it infringes their brand.
Now, Jeff, from my days of startups, when I created a startup, I didn't have the 20 grand to build a website or to put towards these different things. So a lot of this I had to try to figure out a lot of it on my own. Later on, I had different resources to come to the table. Is there a resource that, maybe someone can just start learning, or maybe do a preliminary search on their own? Someone maybe start
Yeah,
up building out of mom's basement or something like that. Is there a place that they could go to find
yeah,
trademark information?
for sure. Yeah, there are lots of different layers, but there's kind of a beginner. We'll call it a beginner's layer, right,
Sure.
to this.
Yeah.
That is the U.S. Patent and Trademark Office. So their website is uspto.gov. That just stands for U.S. Patent Trademark Office. So uspto.gov, and they've got a patent section and they've got a trademark section. And if you go to the trademark section, you can find their search tool right there on their website. And so there are other search tools out there. There's stuff that you can search, internationally, but this is the U.S. version of a search tool that's pretty basic. You just go in there and you type your name in. If we went in there today and we said, okay, let's pull up the trademark search system, and we type in the Deal Scout, we would see everything that comes up that might be related to that name, the specific name, the variations of that name, the graphics with that name in it versus the words that have that name, and it will all pull up, and you can see if they're registered, you can see if they're not registered yet but they're pending application, you can see if they're alive, they've been abandoned. All that stuff comes up. You can read what types of goods and services they're listed for, because every trademark application has to have a corresponding listing of goods and services. You have to say, this is the brand I want to protect, but these are the things that I plan to sell under that brand. So you can see all of that on the U.S. Patent and Trademark System, and do your own quick search there. That'll catch, let's call it 50 to 60% of the things in that simple search net. And that might be sufficient, or that might be all you can afford to do.
Mhm.
And so, better that than doing nothing and launching blindly. I had a friend call me, oh, maybe 2 months ago, and she said, I'm putting, she's kind of into the marketing world, and she had this brilliant idea for a unique conference that she wanted to hold. And she said, hey, I'm doing this thing, and I already went to the USPTO website like you told me to, and I did a search, and I found that I can't call it the really fun, quirky name that I wanted to. So I was thinking about these other variations, right? That's step one.
Yeah.
If I go there and I find stuff, am I going to be too similar to that, and create more risks by launching under that brand than changing it when the cost to change is so low?
Yeah. This may seem like a really dumb question, but I think it's helpful for myself and others. Like, at what point, in what stage is it worth, starting to protect the brand? Let's say I built the Deal Scout and we were producing revenue and we started growing. At what stage does it make sense to, start hiring a legal team or a fractional team, which I love the concept of? Like, at what point is it like, all right, it's time to get this stuff shored up?
Oh, that's a great question, because again, we talked about kind of layers, right? There's also kind of stages as
Uh-huh.
to how you might proceed. And I'm a huge proponent of people, founders, doing everything that they can do as soon as they can do it,
Mhm.
and then stage up when you're ready for it, right? So the very first stage, this kind of brings up a different concept about trademark law. Um, the very first stage for trademark protection is to just start using it. And I know that might sound counterintuitive because you're like, wait a second, I don't know if I can use it or not. Do a little quick search, until you're sufficiently satisfied that you found what you need to and you feel like you're okay with that. And then just start using it. Use it as soon as you use it, essentially you have what are called common law rights in the trademark. Now there's three different layers of trademark protection you can get. The one is called common law, like I talked about. I'll explain what that is in a second. Then there's also at the other end of the spectrum, federal registration here in the United States. So you can actually register it with the federal government. That's what we've been talking about. And that's the strongest, best form of protection. And then there's something that I kind of place in between those, and that's you can actually register your trademark with your individual state. There are some limited scenarios where that's good to do, or that might be all you could do. But typically what we see is we see people relying on common law rights because they've never registered it with the federal government, or they've gone and registered it. So I explain that because your question is when should you start this process? Well, once you start using that brand in selling your services or your products or marketing your podcast in your case, you actually have initiated common law trademark protection for your brand. It's not as good as if you've registered it, like you've also done, but it's something, right? It's a place to start. So to recap, do a quick search, maybe buy your domain names, do a quick search, uh, and then start using it for the types of things you want to use it for. That's almost where everybody starts, although they might skip the search part. So get that search done in between, along with the domains and starting to use it. Then you're started.
Yeah.
Um, once you want to move into a bigger market, or you're making a bigger push, let's call it a bigger investment in your brand. You want to really put your name on your product. You're buying a lot of inventory. Something's happening, and you're putting 50 or $100,000 or more into your business that relies on the branding aspect of your business. It's worth, at that point, in my opinion, it's worth spending a couple $1,000s doing a more thorough search, getting better results, figuring out, figuring out what's going on, and then filing a trademark application. That'll be, in many cases, your best investment for your brand throughout your entire business.
Yeah, interesting. So you mentioned four types of intellectual property protection: trademarks,
Mhm.
copyrights. There was something else, and then patents. What was that something else that I missed?
Trade dress.
What's that?
So trade dress it's like trademarks. You can register it. It essentially is the look and feel of your product, right? So you have trademarks that are specifically brand identifiers. You know, the Deal podcast, Kit Kat candy bar, Snickers, like those are the actual brand identifiers. But then you have other things that are part of, let's call it your business persona, right? You have packaging, colors, and you have specific, like Kit Kat's probably a good example. I'm just thinking of this stuff off the top of my head, and I haven't looked up to see what they have, but they might have on the shape of their individual wafer cookies that snap apart, right? They might have some claims for trade dress because their product looks unique. When people see a product that looks like that, they'd say, "Oh, that's got to be a Kit Kat," right? And they've probably got trademarks that protect it. They've probably got trade dress that protects it. They've probably got patents on their process. Well, there's two types of patents that would apply. They've probably got patents on how they make it and what it is, and then they've probably got something called a design patent, just on the shape of it. And then they've probably got all sorts of copyright protection on all of the marketing copy that they use to sell that thing. There's one product, but there's all these layers. Trade dress is really that layer of, it's not your brand, but it is what people identify the look and feel of your product.
Yeah. So let's just say I was born in a cave and I had no clue what Kit Kat was. And then one day Me and my kids, we created a wafer that's, like layered and it breaks into two, and we didn't know. We had no clue Kit Kat even existed. But we get a letter one day and it's like you're infringing upon all these, and it's hand delivered by, a big attorney with an eye patch and a baseball bat. And I'm
Yeah,
like, whoa, I didn't even know. All right. What what
yeah.
what does it look like when you accidentally infringe upon something with no ill intent, or like what kind of stories are there? Because sometimes I think that fear prevents some people from creating things.
Yeah, yeah, it does. And I think we've stumbled onto a recreation of the Kit Kat commercials that they've actually produced. You've seen them where they have the left half Kit Kat and the right half of the Kit Kat, and they're in two different factories. I just I hadn't planned that, but that's funny. That's you're talking about creating the right half of the Kit Kat when the left half already exists.
Yep.
Um, so so it so let's call that unintentional infringement, right?
Yeah.
You're copying, you're doing what they're doing. You're doing the things that they've already protected, but you didn't do it on purpose, right? So it's infringing, but it's unintentional. That's going to be treated differently depending on which type of intellectual property we're talking about. So copyrights, for example, you have to actually copy, and you can't copy something if you didn't know about it. So in order to infringe a copyrighted material, you would have to first know about it and then actually copy it. If by chance you walked out of your cave or your left half Kit Kat factory and said, "Oh, we just created this. We've never seen the right half before," then you couldn't, if we're talking about copyright, you couldn't have copyright infringement of something you've
Mm.
never seen or didn't actually copy. Um, that's why people can go out and they can, you could read a book that somebody wrote and or whatever copyrighted material. You could look at a painting, one of the paintings I got on my wall, or you've probably got in your office, and you could look at it and you're like, oh, that's awesome. And then sit down and you can paint your own thing. You might be inspired by it, but you didn't copy it, right? So copyright requires intentional copying. Trademarks, on the other hand, and patents don't really require that intention. If you are in the case of trademarks, if your use of a brand identifier has a likelihood of confusion, that's the phrase, likelihood of confusion with another existing trademark out there, then there's a good chance that you infringe their rights if they existed before you did. Same with a patent. If you invent something, whether you copied it or not, if you invent something or you go create a product and it infringes the claims in a patent that somebody else owns, then they would have a right to stop you from doing it. And that's what all this is about, right? The copyrights, trademarks, trade dress, patents, it's all about, can I stop someone else from doing what I did first?
Yeah.
So trademarks intention is irrelevant. Patents intention is irrelevant. Copyright intention is relevant, and the actual facts of copying have to be there.
Yeah. So we'll level up our conversation. Let's just say, Bob the Builder or whoever, probably trademark name too. But let's just say I got
Probably.
a wealthy friend who wanted to invest in my, Kit Kat from the cave. And, he goes along, he starts investing money. Have you seen, investments, especially in the startup world, where an investor will go and they'll invest a ton of money, come to find out, 6 months in, that they have to rebrand, rename, and go through this whole process because they've invested
Mhm.
in the wrong name. Set that scenario, because I think as we're talking from the startup perspective, it surely makes sense to have these things in protective. But from an investor's perspective, or venture capital or angel group who's investing in startups, to have this kind of knowledge.
Yeah, yeah. And I'm gonna broaden it one step further if you don't mind, because you've got the people who are running the business, the people who created the idea, the product. Um, then you've got third parties. Like that would include investors and people who put money in to help the business. But it would also include partnerships, right? If you're going to go enter into a partnership, those same people now they want to join up with you and your brand and your product, but they also don't want to be hurt by you or exposed to risks if there is something that would be trademark infringement or patent infringement. So the scenario that you're describing happens all the time, mostly because startup founders, they're very what are the right words? They're very persistent in their ideas. They kind of move before they think a lot of times, or they move before they make sure. That's probably a better way to say it.
Yeah.
They're all about, validating that product or that idea. They might be infringing someone's trademarks. They might be infringing someone's patents. They might be violating SEC rules. They might be violating banking rules. Like there's a lot of fast and loose movement that happens early on. It's kind of just the way it is. But when somebody else is going to get involved, partners or investors or whoever it might be, this is the purpose of due diligence. So a lot of times that you hear about it a lot with investors in particular, but it happens in other areas too, where when somebody says, "Hey, I want to work with you," there's probably due diligence happening both ways, or at least there should be. Sometimes the investors say, "Well, tell us about your product." That's when you give them the pitch deck and you explain everything and who your customers are, who your partners are, who your vendors are, who your employees are, and they'll look at all of that. If you've been through that process, it's rigorous. You have to build a data room, put all your documents in, and they might be looking, depending on the deal, they might be looking at every last word in every last contract that you've ever signed to make sure that they don't find risks that they don't like. Partnerships are usually not quite that thorough, but they're going to do the same thing. And then they're going to have contracts that say, "Hey, if these things happen, we might need to get out of this deal." Like we've done a number of partnerships, I'll call them, between brands and influencers. And you get these really high profile influencers, and that can really catapult your brand into the public, right? Uh, when one of these influencers, rightly or wrongly, is accused of something that's not so good or not really aligned with your brand, you want to be able to detach from them pretty quickly if you need to. And so you want to put in the contract, "Hey, here's how we're going to work together, and if things go wrong, here's how we're going to get out of this," right?
Yeah.
And they the same thing. "Hey, if you have a huge product liability, your product killing people, you can't obligate me to keep being a public image for your brand." So that happens a lot with partners. With investors, which was your first question, that doesn't happen so much. What happens with investors usually is if the businesses have done their setup right, they just give the investors 1,000 reasons that they shouldn't invest. "Oh, well, we might fail, the market might change, politics could influence what's happening, COVID-19 or pandemics could happen, or we just might not, we just might fail." And so investors are given a lot of disclaimers. "Don't invest with us for all these reasons. But if you do, here's what we're going to do." So investors don't really put together the same uh, provisions to get out.
Hmm.
Once they're in, they're pretty much in, unless there are violations of applicable investment laws. That's when you hear, "Oh, so and so went to jail recently." Somebody here in Utah, where I'm located, it was recently announced they just went to prison or they just got arrested because they violated SEC rules. They violated investment advisory rules. They were doing things. There are a lot of rules, and there's some ways that investors can get out of an investment they made. They might or might not get their money back because a lot of times they want out because the money's gone, right?
Right.
Um, but so those third party arrangements, there's either contractual arrangements or there's due diligence is happening, things like that really should happen at a detailed level, depending on the size of the deal and the length of the relationship.
Yeah. What I think would be super helpful for, the investment groups, the angels, the family offices, the VC groups that I work with to have some type of IP due diligence checklist or some type of person that they can have, examine their portfolio before they write $1 million check because, in your scenario, people want out of an investment typically when the money's gone, and if the
Yeah.
money's gone, you're not getting your money back.
Yep.
Um, for people, let's do this, Jeff. For people who want to learn more about you, about your practice, about fractional legal, and maybe to have you give some insights on on the due diligence, where could people go to connect with you and learn more?
Oh yeah, they can visit. I'm very available on LinkedIn, so I connect with a lot of people on LinkedIn. So look me up, Jeff Holman. I think my caption right now or the lines under my name says I build fractional legal teams. So should be pretty easy to identify. And what that means, what we do at Intellectual Strategies, and you can find me on our website, intellectualstrategies.com. We essentially put together, like I said, a full legal team for each business, and we have everybody available. We have the right attorney with the right expertise available at the right time. That's just what our motto is. And so if somebody needs a patent attorney, they get a patent attorney. If they need a trademark attorney, if they need to do contracts, and over time, because startups are so dynamic and they're moving and they're scaling, their needs grow, their needs decrease sometimes. That fractional team that we build just really kind of grows and morphs and scales with the company so that we can be the right, provide the right services for what they need at that point in time in their growth stage. So,
Yeah.
and the other thing I'll mention is we often do a 30-minute strategy call with new clients. A lot we want to know if just like they want to know, are we the right attorney for them? We want to know, what's your business and is this the type of stuff that we can help solve? Often it is because of our team approach, but still it's a good way to talk about where they're at in their business, what are the big milestones that they're working towards in their business over the next 6 to 12 to 18 months, because that really gives us a roadmap as to where they're headed and what types of things we can expect, what types of things that they can expect, and they might or might already not already know about those things. We can talk about playbooks, how you start to implement legal areas within your team. So we can go over a lot of that stuff in that 30-minute call.
Yeah. And once again, that's intellectualstrategies.com. Fellow deal makers, as always, reach out to our guests, say thanks for being on the show, connect with them, find a way to work together. If you have further questions about copyrights, trademarks, patents, no, trademark dress, right? Did I say right? Or
Trade dress.
copyright dress?
Yep. Yep. Trade dress. Yep.
Trade dress, right? If you have those kind of questions, you can send them directly to Jeff, or you could post them in the comments, whether you're looking on LinkedIn or maybe on YouTube. Post your questions here, and we'll make sure that Jeff gets ringed on that. Now, if you're a fellow deal maker and you'd like to come on the show and talk about a deal or some type of investment, head on over to thedealscout.com, fill out a quick form, and maybe we'll get you on the show next. Till then, we'll talk to you all on the next episode. Cheers, everybody.